Welcome to the last session of this workshop. And this last session is devoted to procedure to be followed by claims tribunals in the new scheme. The last batsman is also in, Mr. Amrinder Singh Shergill. In fact, he's a part of us in Chandigarh Judicial Academy. He joined the Punjab's Judicial Service in the year 2004. Came to the Superior Judicial Service in the year 2015. And he came to Chandigarh Judicial Academy as part of the faculty in April 2021. He would be, in fact, consolidating the entire workshop, which we started with Justice Midda, and then we went over to Mr. Vikas Pava, the senior advocate, Mr. S.P. Jain, advocate again, and Mr. Arora, who is the member secretary of Delhi State Judicial Legal Services Authority. I'm conscious of the fact that many things must have been dealt with, and that is why I'm saying Mr. Shergill would be consolidating this particular workshop in the last session that we are having. May I request Mr. Shergill to kindly make the presentation. Over to Mr. Shergill.
Thank you so much, sir, for your kind words. Good afternoon, all the participants. We are in a workshop in which we are generating an awareness and sensitizing all the stakeholders regarding their respective roles in the newly legislated procedure which has been formulated by Honorable Mr. Justice Midda in Rajesh Tyagi case. It was modified and ultimately finalized, and now the central government has notified it and has made it a part of law. When we talk about the procedure is basically to adjudicate the claims as to the compensation to be awarded to the claimants who can be the victims of an accident involving motor vehicle resulting in death of some person and injury to some person or a damage to the property of a third party. The compensation for the victims of the road accident is very important. The timely dispensation of the compensation, that too of a just and fair quantum, will mitigate their sufferings. Section 168 of the Motor Vehicle Act provides that a just compensation will be awarded by the claims tribunal through an inquiry. Honorable Justice Midda has already sensitized us that we are to hold an inquiry and not a regular trial, as it is a civil suit. The Honorable Supreme Court, in the case of Jayaprakash versus National Insurance Company, has also asked us to conduct an inquiry and not to conduct a trial, as it to be conducted in a regular civil suit. Thereafter, we had Section 169 of the Motor Vehicle Act. It provides that the inquiry is to be conducted in a summary manner through a summary procedure as the tribunal deems fit. So what we were told is an inquiry is to be conducted, and that too through a summary procedure. But what particular procedure? We were in dark, and it was a gray area. The result of the same was that different tribunals were following different procedures, resulting in disposal of the cases in a different manner. Honorable Justice Midha took the challenge and gave to us the claims tribunal procedure, claims tribunal agreed procedure. It was modified thereafter. The Honorable Supreme Court judgments made it applicable throughout the country. But what was noticed is that the procedure was not followed in its letter and spirit. Meantime, Justice Midha further improved it and finalized it, which ultimately was notified by the Government of India, Ministry of Road Transport and Highways, wide notification dated 25th February of this year. So, with the efforts of Justice Midha, with the immense contribution he has provided in this field of law, now we have a uniform procedure in the shape of law to be uniformly followed by all the stakeholders. Stakeholders are the police, who has the primary role to investigate the matter of the accident, the insurance company, the claimant party, and of course the claims tribunal. Through this notification, the Central Motor Vehicle Rules 1989 were amended. It was the fifth amendment carried out this year itself. And through this amendment, this new scheme of procedure came into effect with effect from first day of this month, 1st April 2020. What it has done is, it has inserted a new rule in the 1989 Motor Vehicle Rules. The said rule 150A provides us the procedure for investigation of road accident. It states that the procedure which is to be followed for the investigation of all accidents arising out of the use of motor vehicle shall be in accordance with Annexure 13. Annexure 13 contains the procedure for investigation of motor vehicle accidents. This procedure has not only simplified the manner in which from the taking place of the accident till the disbursement of the compensation amount, how the journey is to be performed, and the important part is it has made the disposal time bound. It has considered three different categories of cases, basically two categories of cases, and one category of cases is further divided into two categories. The first two categories are where the insurance company admits its liability. If the insurance company admits its liability, it has to give an offer in accordance with the various judgments pronounced by the Honorable Supreme Court as to how it is to be computed. And if the same is acceptable to the claimant party, then the claims tribunal is to pass a consent award within a period of 6 months from the taking place of the accident. There can be another scenario where, though the insurance company is admitting its liability, but the offer which has been given by the insurance company is not acceptable to the claimants, or the insurance company has some defense to make. In that scenario, the claims tribunal is to conduct inquiry and to adjudicate that matter. Since an inquiry is required to be conducted, the claims tribunal is provided additional 3 months, making the total time for disposal of the compensation claim within a period of 9 months from the date of accident. Other scenario is where the insurance company do not admit its liability, it has defenses. Then the claims tribunal is to hold an inquiry, adjudicate the matter on merits, and for that, the claims tribunal is given additional 3 months from the earlier scenario by making the total time to be 1 year. The starting date is the date of the taking place of an accident. So this procedure provides us regarding the various aspects and various stages from the taking place of the accident to the disbursement of the compensation amount to the claimants. It starts with that immediately upon receiving of an information that a road accident has occurred, the police is immediately to reach the spot. Before proceeding further, let me remind the police officers who are also attending this workshop that this is a statutory duty. This is a duty which has been put on their shoulders through a law of land. And I'll be touching that aspect also, that any duty which has been casted upon police under this procedure, under this new rule 150A of the Motor Vehicles Act 1989, shall be construed, shall be taken as a duty which the police is to perform under the respective State Police Act. And in case any of the duty is not performed, then the consequences which are provided under the relevant State Police Act will follow. So the police should immediately reach the spot of accident after receiving the information. It has to draw a site plan. It has to take photographs of the scene of the accident, of the vehicles involved in the accident. It has to get a videography done of the scene of the accident and the vehicles involved in the accident. It has to prepare a scaled site plan. In case somebody has got injured and said person is in hospital, then to reach the hospital and take the photographs of the said injury. Before going to the hospital, while doing the remaining things, what else and which is most important is to be done by the police is that it shall examine, record the statements of the persons who were standing there and who have witnessed that accident. The most important persons who can throw light as to what has happened and how it has happened. This is a very important duty, and this comes at the stage 1. After doing this preliminary investigation, within 48 hours, that means 2 days time, the police is to intimate the sad fact to the claims tribunal by submitting the first accident report in the format of Form 1 given in this procedure. That means a written intimation in the prescribed format, Form 1, within 2 days of the taking place of the accident. It is the police which is to submit to the claims tribunal. The same is simultaneously to be submitted to the nodal officer of the concerned insurance company, simultaneously to the State Legal Services Authority, and it is required to be uploaded on the State Police website if there is any. Moment this first accident report reaches the claims tribunal, it has to be registered as a miscellaneous petition. Motor accident claim miscellaneous petition. And whatever reports are filed thereafter are to be tagged along with the same file, same FAR, the motor accident claims miscellaneous petition. After submitting the FAR to the claims tribunal, the duty put on the shoulder of the police starts. The first duty which has been put on the shoulders of the police after submitting the FAR is to make aware the claimant party, the victims of the road accident, as to their rights. And further, to be provided with the flow chart of the scheme Justice Mehta has discussed in the first session. The rights of the victims and the flow chart of the scheme is given in Form 2 of this procedure. And if somebody has died in the road accident, then to his legal representatives, this form is to be given. And the time period which has been provided to the police to do the same is 10 days. Thereafter, the police is to investigate the different aspects. One of the aspects is the validity of the driving license held by the driver. To obtain the requisite information along with the requisite document, the investigating officer will provide a blank form. The format is given in form number 3 to the driver of the vehicle, which is involved in the accident, to furnish the relevant information in that form number 3 to the investigating officer within a period of 30 days from the date of accident. By gathering this information, the police is to verify the said information, and after verifying the information is to submit further reports in the matter to the claims tribunal. If form number 3 is to be given to the driver, then form number 4 is to be given to the owner of the vehicle involved in the accident in the blank form, so that the owner of the vehicle may provide the relevant information, including the documents, the registration certificate of the vehicle, the fitness certificate of the vehicle, the permit document of the vehicle, if any. This information is again to be provided within a period of 30 days to the police, so that the police may further verify it, and after verifying it, to submit it to the claims tribunal along with the reports which the police is going to furnish. After obtaining the information from the driver, from the owner within a period of 30 days, after examining the eyewitnesses, the people who were present at the time of accident, after preparing the site plan, taking photographs, doing videography, etc., etc., the police will complete an interim report of the accident under clause 6 of this procedure in the prescribed format given under form 5, and the report is called as interim accident report, IAR. Initially we had, within a period of 2 days, first accident report, FAR. Now, within a period of 50 days from the accident, from police, the claims tribunal have the interim accident report. This report is also to be submitted to the insurance company, so that it can also have a look into it and can further cross-verify, cross-check the various aspects and the facts contained in it. It is also to be submitted to the victims or the claimant party. It is also to be submitted to the State Legal Services Authority. It is also to be submitted to the insurer. It is also to be submitted to the general insurance company. The idea is whatever report the police has submitted after within a period of 50 days from the accident, after gathering the requisite information and thereafter verifying it, it should come in the notice of all the stakeholders who are involved in adjudicating a claim regarding the compensation to be paid in a motor vehicle accident case. Thereafter, whatever the information the driver has given in form number 3 or the owner has given in form number 4 is to be verified by the police. And after completion of the verification, it has to prepare and fill in the columns of the prescribed format, Form X, Form 10. And this Form 10, which is a verification report as to the facts disclosed by the driver and the owner, and as to the documents provided by them. And this report in Form 10 is to be submitted to the claims tribunal along with the subsequent report to be filed. That means there is obtaining of an information. Thereafter is its verification, and thereafter submission of the same before the claims tribunal. What we gather from this is that the inquiry to almost most of the facts have been systematically done by the different stakeholders, the police and the insurance company, in the prescribed formats, and that verification is that information is verified, then it is cross-verified. And after verification and cross-verification, it comes before the claim tribunal. And thereafter, what remains is just a mathematical calculation, and the compensation amount is to be calculated. We had the information from the driver. We had the information from the insurance company, the owner. Now comes the stage when certain information is obtained from the claimant part as to what was the age of the deceased, what was he doing, what was his income, what is the document regarding his income, how many people were dependent upon his income, etc., etc. So as to calculate the dependence. This information is gathered from the claimant party, from the legal representative of the deceased victim of the road accident, by furnishing them a blank copy of form number 6. And for furnishing back this information in the said prescribed format, the claimant party has a time period of 60 days from the taking place of the accident. There can be a scenario when a victim who has got injured and is lying in the hospital, or who has died, has a minor children. If the children are there, then two agencies are simultaneously involved. That is the Child Welfare Committee, to see whether that child is in need of care and protection. The Legal Services Authority, to provide the legal assistance, the legal services required for that child to obtain the redressal of his grievance, his rights provided under law. And this information will be in a different format. That format is Form 6A, which is again to be given by the police to the claimant party, legal representative of the victims, to be furnished back within 60 days from the taking place of the accident. Form 10 is the verification report of the police. On the other hand, a cross verification takes place from the insurance company as to the particulars which have been furnished by the claimant party in Form 6 and Form 6A provided by the police to it. Then the said verification is also to be submitted to the claims tribunal after initial investigation, first accident report, later investigation, interim accident report. All the information which is gathered is verified, cross-verified, and a final report is prepared by the police, called as detailed accident report. The format of the same is provided in form number 7 of the procedure, and the time period which has been fixed for submitting the DAR is 90 days from the date of accident. The DAR will be accompanied by all the relevant documents, the site plan as per format given in Form 8, mechanical inspection report of the offending vehicle as per the format given in Form number 9, as per the verification report format Form 10 of the police, and the report, the Challan report submitted under Section 173 of the Code of Criminal Procedure. This copy of the DAR is simultaneously to be provided to the victims, the claimant party, the owner, the driver of the offending vehicle, nodal company, the nodal officer of the insurance company, the General Insurance Council, and the State Legal Services Authority. In the said process, it may happen that the information which police is seeking from the driver, from the owner, is not being provided to them. Is the documents are not being provided to the police. Police is not helpless. What it has to do is, under clause 14 of the procedure, to approach the claims tribunal, move an application seeking direction to the defaulting party to submit the requisite information directly with the tribunal within 15 days from moving of the application. So the police is not helpless. If the cooperation is not given by driver, owner, insurance company, claimant, police can approach the tribunal, can obtain the directions, and in that scenario, the information is to be directly given to the claims tribunal within a period of 15 days. After receiving the FAR, we have registered a miscellaneous petition, motor accident claims miscellaneous petition. Now the DAR has come. After the receiving of the DAR, which is to be treated as a claim petition, it has to be registered so. But sorry, I was missing one thing, that there can be certain circumstances which are beyond the control of the police to submit the interim accident report within 50 days or the detailed accident report within 90 days. And the said reasons which are beyond the control of the police can be that it is a case of hit and run accident, the culprit, offending vehicle could not be located, the parties are residing at a distant place outside the jurisdiction, the driving license is from a distant place outside the jurisdiction from where it has to be verified, or the victim are in hospital and they are not in a medical condition to suffer their stay. In those exceptional cases, what the police is to do is to approach the tribunal and seek the extension of the time. As per the facts and circumstances of the particular case, the claims tribunal is to grant the extension. But again, only for those exceptional reasons which are beyond the control of it. After the receiving of the FAR, IAR or the DAR, what the claims tribunal is to see is to examine it, whether they are complete, they are in the prescribed format, the requisite documents are there, being produced before the claims tribunal. Not after receiving the DAR, but after obtaining the presence of all the concerned persons through the police, through the investigating officer, the DAR or the FAR which was registered as miscellaneous petition to which IAR was tagged, to which DAR was tagged, is to be registered as claims petition, a regular claims petition, motor accident claim petition. And if the police is unable to produce any of them, then it will obtain the notice to be served on the responsibility of the IO, on the concerned person, and procuring of the presence of that person before the tribunal will be the responsibility of the police. Now, there can be two scenarios. The DAR discloses a case of rash and negligent driving. If it discloses the case of rash and negligent driving, what is to be done by the claims tribunal is to register the claims petition under section 166 of the Motor Vehicles Act. If it do not disclose the rash and negligent driving, or the claimant party chooses to obtain instant compensation on no fault basis, then the said DAR, after procuring the presence of the concerned parties, is to be registered as a claim petition under section 164 of the Motor Vehicles Act. Hereafter, the important thing which has been done by this very procedure is that the inquiry is to be conducted. The inquiry is to be conducted for the satisfaction of the tribunal regarding only those aspects which the police or the insurance people are not able to confirm. And for that, section 165 of the Evidence Act is to be invoked. As Justice Mehta has said, the tribunal is to take the driver's seat in conducting the inquiry as per this procedure in a time-bound manner, and it is always free to summon the concerned person and put a question on behalf of the claims tribunal to know the exact matter, to know the better truth. Thereafter comes the stage that the tribunal concludes the inquiry, consent award, or meritorious adjudication of the admitted liability compensation amount or the disputed liability compensation amount. Before passing the award or at the time of passing of the award, the claims tribunal is to examine the claimant party. The purpose is to know what is their financial condition, what is their financial need, how much money they will be requiring per month for the annuity scheme in which we have to deposit the compensation amount as told to us by Justice Mehta, and how they would like to get that money. And for that matter, the claims tribunal is to obtain from the claimants the Aadhaar card, the PAN card, the details of the bank account, which is Aadhaar linked and which is near to the place of the residence of the claimant party, 2 sets of photographs from the claimants, and 2 sets of specimen signatures. And this information is to be mentioned by the claims tribunal in the award itself by directing the respondent to pay the amount in the said account. Thereafter comes the deposit of the award amount. It has to be in the annuity scheme. How much amount is to be disbursed, when it is to be disbursed, it will depend upon the facts and circumstances of the case, but it has to be protected by the claims tribunal so that if it remains unprotected, the entire effort will go in vain. Thereafter comes the most important part, which will help us to a great extent, is that there is a format given in this procedure, Form 15 in death cases and Form 16 in injury cases, where we have to incorporate in our award the summary of computation of compensation. How we have computed, how we have calculated the compensation. And then there is a prescribed Form 7 format, which is again to be mentioned in the award, which is the compliance of the procedure, this procedure. And we can have the assistance from the litigating parties by obtaining written submissions from them in the prescribed form. This is, in short, the overview of the new procedure. Do go through it. Do read every provision carefully. There are specified formats given in the forms thereafter, which will be helpful in adjudicating the claim cases within the prescribed. With this much, I thanks each and everyone for the patient hearing. Thank you so much. Over to you, sir.
Thank you so much, Mr. Shergill. Short, crisp, and yet covering everything.
Sorry, sir.
What is required as such. With this, we are also concluding the workshop today. I feel that this workshop has come out very well, having the first session with Justice Midda. I specifically acknowledge his contribution and grateful to him for having spared the time and made rich contribution, not for the workshop alone. He is, in fact, the one who has been instrumental as a judge, and thereafter imagine that the rules were framed in such short time. Normally, when a judgment is given by an ordinance, they would try to overrule the judgment. But here is one particular judgment which has been translated into actual practice through the medium of rules which have been framed in this particular context. And thereafter, Mr. Pava, Mr. S.P. Jain, Mr. Arora, and now Mr. Shergill, all of you have covered the different aspects. I thank each one of you and look forward to the contribution in the future workshops that we intend working out in the Chandigarh Judicial Academy. Thank you, everyone, particularly the participants who have contributed by being effective